Yes, please call the list.
From the main list, item number 1.
Oh yes, Weybridge, yes. So where is this? You have not filed a report as yet?
Sorry, this is the transport. This is the.
Because the state was supposed to file a report
Yes, my lord.
in the form of an affidavit. Where is that?
From the main list.
From the main.
Sorry, Lordship, we thought it's a supplementary list.
My lord.
Huh?
Oh, we mistook that the supplementary list matter has been called.
This supplementary list.
You're there. Yes.
So you are there, yes, yes.
My lord, we as far as number 1, item number 1 is concerned, my lord, we have just received the instruction, my lord, from the government. So, my lord, I need 1 week time, my lord, to file the affidavit, my lord.
Not 1 week. 1 week will be we are closing, not 1 week. If you have the instruction, you can just put it in affidavit. It's a matter of 1 day.
My lord.
So just give me the calendar, please. Oh, yeah, no, fine. So will be on the prayer of the Land Council for the state, the matter since adjourned till yes. Judgment. Huh? The judgment has not come. First, every day you first call the supplementary list, then you call the main. Yes. Yes.
From supplementary list, item number 1, pronouncement of judgment.
We just read out the few concluding paragraphs. We discuss the judgment cited by Mr. Shah. In our respectful reading of the said decisions, the doctrine of group of companies would apply provided there is an intention of a non-signatory to be a party to the arbitration agreement. For the purpose of a non-signatory to be a party to the arbitration agreement, the said non-signatory should be in existence on the date when the agreement was entered into. Admittedly, on the date MOU was entered into, the present appellant petitioner was non-existent, and hence the ratio of the aforesaid decisions would have no application in the instant case. Moreover, as mentioned earlier, the private party has made several communications asserting its right in the MOU, which clearly shows that the present appellant petitioner has been consciously excluded with regard to the enforcement of the right under the MOU by the private partner. Curiously, the private partner, in spite of their existence, did not approach the court or initiate arbitration proceedings where the termination of the MOU. We could not find any satisfactory answer for the private partner to remain silent. Accordingly, we are of the view that the application under Section 9 at the instance of the appellant petition is not maintainable, as the appellant petitioner is not a party to the arbitration agreement. Corrections are there, corrected. Then we'll sign it.
All applications and contempt petitions are
Yes, all are disposed of.
Great.
Number 2,
Actually, keep this in the other file. Yes. Yes.
Lordship, this matter is connected to a writ petition number WPC 281 of 2017, Lordship, which is listed on 10th, Lordship. The scheme is to be notified by the state government, Lordship.
Can't hear you. The petition was dismissed.
Lordship.
The
This is
writ
an
petition
appeal,
was
Lordship,
dismissed. So you are the appellant.
yes. Lordship, I'm for the appellant.
Yes. So what do you say?
Lordship, this matter is connected with WPC number 281 of 2017, Lordship, which is listed on 10th, Lordship. There the scheme is to be notified, Lordship, and this matter has a bearing on that matter, Lordship. It's a connected matter, Lordship.
Where is the last order?
Last order is, Lordship, of 9/10/2025, Lordship.
Yes. Oh, so this matter was to be heard. This matter was heard, no? This notification of the scheme.
It came yesterday, Lordship.
Yesterday we heard.
Might have an impact. We not
No, but this matter was said to be listed on 9th December, but the other matter is on 10th December.
10th, Lordship. 10th.
Reducing the necessary.
It may have some bearing
It may have some problem. Very well.
because this is the scheme.
You are. What is your good name, please?
Mr. S. Chanda, Lordship.
S. Chandan. Mr. S. Chandan, the Land Council, appearing on behalf of the petition appellant, has submitted that yes. Yes, what is the matter? What is this matter? The appeal is for the appellant. You are for the appellant. So you have to file a paper book because there is no scope for any interim order. You file a paper book. Are you asking for any stay?
But here what happened, my lord, while section 34 application was pending, my lord, they filed an execution petition. So we've deposited 50% of the amount before the trial court, my lord. And that has been released to them on submission of a bond, my lord. So that way they are secured, my lord. 50% of my amount has already been paid to them.
No, but the provision is that you have to pay the 100%. 50% is not the provision. They have to secure the amount. That is what the. I have the books. Please bring the books. I brought the books. Why my books are not kept here, I don't know. Ask them. Stay, then you have to secure the entire amount. Normally, initially the plea that the government may not have to deposit, that has been settled by the Supreme Court in the PAM developers. They said not. You have to secure whether it's a government or non-government.
But here what happened, my lord? The arbitrator has awarded about 90 lakh rupees, my lord. Against of that 50% we have deposited before the trial court. My lord.
But if you are asking for the stay,
Now, my lord, the section 34 court is reduced, my lord. They've set aside one claim, my lord, or by reduced by 25 lakh rupees.
So it comes to 75 lakhs. Rather, 65 lakhs.
65 lakh and 45 lakh rupees has been deposited, my lord.
But you have to deposit the balance if you want to secure a stay. If you want to issue secure a stay, you have to.
We can do that, my lord.
And then we hear out the appeal.
My lord.
You have filed an application for stay. अरे सब किताब जो आया ना
Only an interim prayer has been made in the main appeal. My lord.
हाँ?
An prayer for interim is made in the appeal itself, my lord.
No, is there any no, are you agreeing to any amount? Let us for the
But
time
in fact, I called up the officers of the department, my lord. They are finding it difficult to figure out, my lord, which claim to concede and not to concede, my lord. In fact, I have submitted a summary, my lord, on the last occasion. Lordship kindly sees
yes,
page.
that you have submitted. But if you want to stay,
My lord.
if the execution proceeding is stayed, no problem. Execution proceeding has been stayed or not?
My lord, because I only have a copy of check. Maybe it was a precondition for section 34, my lord.
Sorry?
This 50% was deposited in section 34 proceedings, my lord.
So whatever you have amount deposited,
Yes, my lord.
if it is still lying with the court,
It has been released to them, my lord, and they've furnished a bond to the court, my lord.
Yes, Lordship, it has been released to us. May I please, Your Lordship?
but how this amount could be released to you, madam, without you have furnished a bond?
Yes, we have furnished a bond before the trial court.
I think we said something last time. What did we say? I can't recollect. This matter was hard, I think, by us.
My lord, this matter was heard, my lord. Your lordship had a tentative view, my lord, that claim number 1 and 2, if the department could consider, because claim number 6, where loss of profit has been given 15 lakh rupees, my lord, by the arbitrator, and which has been
we
upheld
said
by.
1 and 2, yes, correct, you're absolutely correct.
So,
Possibly C also.
yes, my lord.
C also.
Claim number 4, 5, which is altogether 11 lakh has been given, my lord, and claim number 6, 15 lakh has been given, if department could consider the first 3 claims, my lord.
Yes,
That was your
yes,
lordship's tentative view at that point of time, my lord.
First 3 claims, you're absolutely correct.
Yes.
So, what is the view of the department on the first 3 claims?
Well, the department is not able to give any concession, my lord.
Not concession. See,
Well, I told them, because if we concede to some extent, my lord, we gain on claim number 4, 5, and 6. And that is a substantial gain, my lord. My lord, what I can do, my lord, we will deposit some amount, my lord, before the registry of this honorable court. And in the meantime, I'll talk to the department once again, my lord.
how much amount you have received so far?
50% of the principal amount,
This is 45 lakh rupees, the entire amount has been
45
registered.
lakhs.
Well, that check has been annexed at page 224.
Very well.
And Lordship has also directed me to submit all the documents which was submitted before
Now
the
let
arbitrator.
paper book be filed, because now this matter is not likely to be settled at the hearing of the appeal, isn't it? You file a paper book.
Lordship, I'll file a paper book. I'm preparing
Very
them. It's just that I need the signature of my client. So I'm waiting for that.
No, for paper book, you don't need your signature. Paper book, you can
If it
also
is in a
file.
form.
Whoever wants to
yes.
file a paper book.
Lordship, then I
Welcome.
can file it, Lordship.
Should we record that is the execution proceeding or in the section 34?
Section 34, not the execution, because execution was stayed and
Very
disposed of.
Very well.
My lord, in fact, page 22, my lord, when we deposited the check
During the pendency of the application for setting aside of the award under section 34.
Yes, Lordship. Lordship, I beg to apologize. Due to oversight, Lordship, we have not been able to prepare.
Sorry.
I'm sorry, Lordship. I beg to apologize. We were required to prepare a paper book, Lordship. Due to oversight, I could not prepare it.
There's a direction for paper book.
Lordship, on the last occasion, Lordship had directed for preparation of a paper book.
28th October.
Due to oversight, my lord, I beg to apologize unconditionally.
No, but we want to know what is the stage of the departmental proceedings and what is the stage of the criminal proceeding.
Departmental proceeding is, Lordship, at the stage of the petitioner, who is the delinquent. He has been asked to submit his defense statement.
And what is the stage of the criminal proceedings?
Stage of evidence, Lordship, examination of the prosecution witnesses.
5 or 6 witnesses examined.
Lordship, 5 or 6 witnesses have been examined, and there
The
are
criminal proceeding.
In the criminal proceeding.
in the criminal.
Is it a criminal breach of trust?
Lordship, Prevention of Corruption Act, along with Criminal Breach of Trust, 406, 468.
Charge sheet in both the charges are same in both departmental proceedings and
Same common witnesses, common allegations. It was arising out of a misappropriation in the post office. That
no,
was
that
the
we remember, but
Well, charges are basically the same incident. Well, the wordings are different. Well, and the purport is different. The criminal trial is different. Well, departmental proceedings is different.
what is this that? Proceeding has progressed substantially.
Well,
Then we'll stay the defense statement, let him file. Defense statement, let him file. We just wait for the criminal proceedings to come to an end. And then we'll take a call that whether depending upon the nature of the findings in the criminal proceeding, we may decide on whether he should be, whether the departmental proceeding can continue or not. Although there is no bar as such for simultaneous
yes.
this there, but there are exceptions carved out
Yes.
in the Paul Antony's case,
Yes.
and there are subsequent decisions as well. But he wants stay of the disciplinary proceedings.
Yes. He went to tribunal.
And so what do you say to it? Because if the criminal proceeding has substantially progressed, and if we direct the conclusion of the we'll make an observation, we cannot give a direction as such in this proceeding. But our observation would also be
Because one aspect, my lord, to be considered, because criminal trial may take some time, my lord.
something.
It may take time, my lord. That's one thing. Since 21, my lord, 4 years, only 4 or 5 witnesses have been examined now.
Now, how many witnesses are there?
There are 25, my lord.
25 witnesses.
Hmm? Hmm? 25 witnesses.
Lordship, 25 witnesses in the criminal trial.
My goodness. Then the charge will never be proved. They hurriedly prepared a list of witnesses, either to destroy the case or to comply with the statutory requirements.
CBI is prosecuting the case, my lord.
No, I'm saying that either they disregard the provision of the evidence side that one witness is good enough to prove a case. Number of witnesses. You represent CBI also.
Yes, ma'am.
In this matter, are you representing the
No,
CBI?
not with the trial court. They have a special public prosecutor.
Talk to the public prosecutor. Why you require 25 witnesses? They can shortlist it. The Starling witnesses. They must have the Starling witnesses.
But I can talk to them. But here, what happened, my lord? He was working in post office, and what he
No,
did.
we have read your judgment. We have read the judgment.
See, siphoned of the money from account depositors' accounts, my lord. That's why all the depositors have been made. Many of them as witnesses.
Paragraph 15, in fact, he has said 25 witnesses. And in the departmental proceedings, there are only 10 witnesses.
Yes, my lord.
The list is there at 102, Lordship, of witnesses.
Well, what they've stated in their petition, they're agreed with 8 witnesses who are common witnesses in criminal case as well as in the
There are
department.
8 common witnesses between the criminal trial and the departmental proceedings.
At page 19 of the petition, they've made a chart, my lord. They mention it here. And 2 of them are co-accused also, my lord.
All the papers are not on record.
Lordship, in my writ petition, I have enclosed all the documents which were before the Central Administrative Tribunal, and thereafter I have filed an additional affidavit, bringing on record the order by which charges were framed in the criminal court, Lordship, because that was not in the record of before the CAT.
Very well, take down. On the
From the witness, item number 1.
May it please yours. Lordship, I have filed application to condone the delay in preferring the appeal. The delay has occasioned, my lord, on account of the fact that there was some bona fide mistake in construing the judgment and order of learned single judge, my lord. It's not deliberate, my lord, because the judgment and order of learned single judge, my lord, was construed as only direction to consider in accordance with law, my lord. If I can place that judgment, my lord. Because the petitioners approached the learned single judge for regularization of their services, my lord. And the learned single judge, by order dated 5th September.
Paragraph 8 says, accordingly, this writ petition is disposed of
Yes, my lord.
with the direction that the respondents consider the case of the writ petitioners.
Yes, my lord.
By looking at the vacancy position in the department
Yes, my lord.
and to take steps in accordance with law to consider the regularization.
Yes, my lord.
So you have to consider whether they can be regularized or not.
Yes, but the issue is that in accordance with law means, my lord, I have to see the roster, I have to see the advertisement, I have to see all these aspects, my lord. So therefore, now my the colleagues, the client of my learned friend, my lord, they have filed the content, construing that there is a positive mandamus to regularize them, my lord. And we were under impression, my lord, that it is only consideration, and we have filed repeated affidavits before the learned single judge, stating that we have considered them, we have given age relaxation, the process will be followed for their regularization. But my friend's client, they are saying, my lord, that no, there is a positive mandamus. If your lordship will see kindly the direction, that it has got twofold direction, and that is how where the mistake has occurred in not preferring the appeal.
No, you see that the footnote on which reliance was placed
Yes, my lord.
is at the internal page. What is the page?
22, my lord.
Yes, you are requested to apply, correct?
Yes, my lord.
You are requested to. Have you got this?
Yes, the present officiating is
You
temporarily
are requested to apply to the Secretary MPSC Shillong as soon as
yes, my
the
lord.
post of the manager sericulture inspector is advertised.
Yes, my lord.
So had it been advertised?
Yes, my lord. And
No, my lord.
we are in the draft advertisement was placed on the record.
So their cause of action would arise once you advertise it.
Yes, my lord.
Before the advertisement, their cause of action would not arise.
Yes, my lord.
Now, once they advertise,
Yes, my
then
lord.
they would be allowed to make an application.
Yes, my lord.
For regularization of your appointment, the present officiating is hereby temporary, and unless you apply to commission
Yes, my
and
lord.
recommended by it for regular appointment to the post, you are liable to be discharged
Discharge at any time. Yes, my lord.
For regular appointment to the post, you are liable to be discharged any time. You are requested to submit at any time. You are requested to submit the joining report, such and such, medical fitness.
Yes, my lord.
So the right of cause of action arises once you advertise it.
Yes, my lord. That's
Present
our understanding.
Officiating is hereby temporary. So what you are officiating for all this will be temporary.
Yes, my lord.
And
And if you
unless,
lordship will see,
and
if
unless
not-
you apply to commission,
yes, my lord.
hereby temporary, is hereby temporarily, it should be temporary,
Yes, my lord.
here is a temporary, and unless you apply to commission
Yes, my lord.
and recommended by it for regular appointment to the post,
It's a temporary appointment, my lord. And page 20, if your lordship will see at the beginning of the notice also, 18th
This is
March 2020.
2010 appointment.
Subject to discharge without notice and without assigning any reason thereof following so and so, my lord. So stipendiary candidates who have successfully completed the postgraduate diploma in sericulture. And we have got large number of stipendiary candidates in other branches also, my lord. So our understanding of the order of the learned single judge was, my lord, that we have to consider in this process. But in contempt, my lord, and if paragraph 7, your lordship kindly have a look at paragraph 7. Looking into the situation of petitioners, that is no doubt they are not possessing any legally enforceable right to seek regularization to the post, but however, in the considered view of this court, their case deserves some consideration by respondent in view of the footnote that had appeared in their respective appointment letter. Accordingly, this writ petition disposed of with direction that respondent consider the case of writ petitioner by looking at the vacancy position and take steps in accordance with law to their regularization below. So
The whole issue is
No, you see that the Lada Single Judge has said that we cannot issue a mandamus.
correct, my lord.
But in considering your representation,
Yes, my lord.
what is required to be seen is that you are appointed against a regular vacancy,
Correct, my lord.
vacant sanction post,
Correct.
and you have been afforded regular pay scale.
Correct, my lord.
So, which are all the trappings of regular employment? The case of the petitioner cannot be said to be absolutely without any merit, as also seen from the order and such. In that case, however, it is seen that the department had issued a draft advertisement for regulation of services along with an approved list of special recruitment. Now,
Yes.
these are all special recruitees, correct?
For special recruitment, my
Huh?
lord. The direction is for to consider the regularization for special recruitment.
So you consider it. You consider it for the purpose of
What's
special
the-
recruitment.
what
Yes,
the-
in the draft
what the-
advertisement.
What the state is doing is they're having an open my lord, advertisement.
in which the
2010 we were appointed. Nothing has been done by the department to fill up the post.
So
we then approached this honorable
Sir,
court.
these posts will although these posts, although you have been appointed, will be treated as a vacant posts.
Yes, my lord.
Because it is not a because you are being temporarily appointed.
Correct, my lord.
So these posts has to be treated as a vacant post.
They haven't closed.
But regard may have to the facts that you have been appointed in 2010
Correct, my lord.
and serving this institution for so many years. maybe.
Yes, my lord. And
we have given the age, we have come out with the notification giving the age relaxation to them. They can participate, my lord.
my lord, that is
But
open
there
recruitment.
is no mandamus that it's only consideration.
Yes, my lord, that to that extent, if in my appeal it is clarified, my lord, because I am facing contempt and there is and we have explained the position in contempt repeatedly, my lord.
But no rule of contempt has been issued against you.
You, my lord, the notices and my lord, we have given 3 affidavits in the contempt petition, and it has been construed in this manner, my lord. So to that extent, we are aggrieved, my lord, because what my friend is construing that direction is to regularize them.
No, my lord.
Direction is to
consider.
regularize them, and then there is.
Consider, my lord.
See, what the contempt court would do ultimately.
Yes, it is
we
a
cannot-
separate matter, my lord. I understand, my
But
lord.
this order doesn't.
But
give
this
them-
has got 2 aspects, my lord. In the appeal, if your lordship will see, because this direction, consider the case by looking into vacancy position in the department and take steps in accordance with law. So I have to see the vacancy position, my lord. So these posts are vacant, my lord, as of today, because they have been appointed. The terms of appointment itself says, my lord, discharged without notice and without assigning any.
My lord, their affidavit before the contempt.
The writ court has not directed you that you mandamus directed them to regularize it.
No, ma'am.
But you consider the case of regularization.
Yes.
Yes, so the process of regularization is, my lord, I have already, your lordship has taken note that we have issued the draft advertisement. Now my friend is saying that draft advertisement is not in consonance with the order of this honorable court, learned single judge, my lord. My case is that this is the process, and if your lordship will
So
see the
let the decision come, because we will be putting the cart before the horse.
yes, my lord, but
Correct, my lord.
the issue is, my lord, the issue is, my lord, that the appeal, because the appeal is on 2 grounds, my lord, in my submission. One, my lord, is that this is, if to that extent, if your lordship clarifies this appeal, my lord, that
Clarification can be sought from the trial court. Why clarification from us?
yes, my lord, to the extent my appeal is, my lord, if
In case you find any ambiguity in the order, you are seeking a clarification. If on the clarification, if the learned single judge say in effect it is, then you prefer an appeal.
no, what, my lord, your lordship have this matter in the month of February, my lord.
No, my lord.
I am seeking simple adjournment.
We are passing an order, it will not affect either of you. Take down. The full stop. There's a delay of Let's call the list.
On supplementary list, item number 1.
Yes.
May it please your lordship, in this matter, my lord was pleased to grant me some time to research into that rule, my lord, Rule 34 of the administration. My lord, my only humble submission is that, my lord, in this aspect, my lord, I have research also, my lord. I'm quite close, so kindly grant me some time, my lord. That's my humble request.
No, your plaint was rejected.
My lord, this is the
Your
case.
prayer for rejection of the plaint was dismissed.
Yes, my lord.
Because of this chapter, Roman 4, Civil Justice Rule 34,
Yes, my lord.
of the laws of administration. Where is this book? Do you have the book? So this is clearly provides for this.
My lord, my humble submission, my lord, kindly hear me, my lord. My lord, Limitation Act 1908 has been repealed, my lord, to 1963, yes, my lord. And 1963, Section 1, my lord, if you will see, my lord, the Limitation Act extends to the entire state, the entire country, my lord. And which is now amended, even the Jammu and Kashmir also has been excluded, it has been included. The Limitation Act will also be applicable there. And my lord, another aspect, my lord, in this judgment, which I was referring previously also, my lord, it is specifically written here, my lord, that the Limitation Act 1963 applies to the entire state of Meghalaya, including the tribal areas of autonomous district or regions, my lord. So, my lord, there is no issue on the applicability of the Limitation Act, my lord. Of course, my lord, in 1908, my lord, in the rules of this chapter 4 of Civil Justice Rule 34, it has not been amended yet, my lord. It has not been amended yet, my lord.
You see that Limitation Act is a general law.
Yes, my lord.
This is a special statute.
Yes, it's a special statute.
If a special statute
Correct, my
says
lord.
that the Limitation Act will apply or not apply. Now, before in the three-judge bench decision,
yes, my lord,
where it says that where you show us from this judgment,
yes, my lord,
that this provision was considered.
Yes, my lord.
Show us.
My lord, kindly come to page 36, my lord, of the judgment. Conclusion part, my lord.
36, yes.
The Limitation Act 1963 applies to the entire state of Meghalaya, including the tribal areas of autonomous district or regions.
No. So, in deciding that,
yes, my lord,
did the full bench have taken into consideration this particular statute?
My lord, in that aspect, my lord, this statute, my lord, was not taken into consideration. I agree to that, my lord. I agree to that, my lord.
This is a judgment which was not even considered the statute.
My lord,
while reading to this, the provisions of this is with regard to the dispute between the tribals and tribals. So tribals and tribals are governed by the district council.
Yes, my lord.
This district council have their own rules and regulations. That rules and regulations are subject to correction, are not being abrogated or touched by the Reorganization Act. It's only the state is being demarcated.
Yes, ma'am.
So in the state is demarcated, obviously adaptation of the laws, whatever is there, unless because a new assembly, a new state is born with a new assembly. So there could be adaptation. If they have not adapted, is one thing. But so far as this district council are concerned, they are in no way affected by this reorganization. Only thing, geographically they are located now, instead of in Assam, they are being located to Meghalaya. But their own rules and regulations have remained.
My lord, for example, my lord, previously even CPC and CRPC was applied only in spirit, but not in letter, my lord, in district council. But that also has come into clarification, white notification, which now it applies fully, my lord.
No. With that we clarified. That we passed it clarified. We said that
there is a notification.
Yes, that notification we had.
Yes,
discussed that notification. We said that Schedule 6, 6th schedule, I think, clause 5, we have notified that power remains. So CRPC, it is only for the purpose of appointment or conferment of power. But whether the CPC or CRPC would apply or not, that will be governed by whatever the existing things are there.
But my
So
lord,
you cannot, because the sixth schedule protects them.
my lord, in this Shella Committee judgment again, my lord, the law, the provision of law here, my lord, wherein applicability of the Limitation Act has been
No,
specifically.
this sentence including, you show us from this judgment where this part has been considered.
Yes, my lord.
It's completely the issue was as to whether provisions of the Limitation Act do not apply to the tribal areas.
Yes, tribal areas now comprising the state of Meghalaya. So, my lord, in this aspect, my lord, I would like to
This is
seek
what you
another
say to this. What you said, this three-judge bench decision is there. What do you say to this? Because there's a specific reference and specific answer to this.
Lordship, first, in page number 124, it's all 124 of the petition in this petition.
124. Yes.
Yes. This is the application order 6 rule 11.
124. Yes.
And Lordship, please take page number 128.h.
I sought recovery of 49,000, which is paid to the defendant plaintiff, provided the details of the money given. Plaintiff claimed that the money through checks on different dates between April and April have been given. That further in para 9, the plaintiff has mentioned the cash amount of this city paid to the defendant prior to the transferring of the opposite amounts. It is Benami Transaction Act, yes. It is Benami, but laws of limitation, they said laws of limitation.
Yes, Your Honor.
So if the laws of limitation is applicable, then it's more than 3 years.
Your Lordship here in this case, in the order page number 27, which is passed by the judgment and order from the District Council Court, which Your Lordship take the para 4.
Para 4.
Yes, Your Lordship. And it clearly says
Paragraph 4 of the judgment.
The
Yes, Your
impugned
Lordship.
judgment, my lord.
Huh?
Your judgment.
He's talking about the impugned judgment.
This paragraph 4.
Because the learned trial court has.
Says the runner ignored it. No, sorry. Paragraph 4. No, you are referring to page, which page? There is no paragraph number.
Page 26, Your Lordship.
This is page 26. Of the impugned judgment.
Yes, Your Lordship. Here all the limitations and it's totally
No, you see the learned single trial court has relied upon this chapter Roman 4 civil rules 34. To say that except in so far as provided by this limited shall not apply to seats in which either or both parties are member of a scheduled tribe or tribes. So this judgment in effect,
It was already rejected in the district council also, Your Lordship, in lower court.
My lord,
it's not the point. Point is this, whether the Limitation Act would apply or not.
No, Your Lordship, it doesn't apply it under the under the Chapter 4 Civil Justice Rule 34 of Law of Administration of Justice in Meghalaya.
my lord, again here, my lord, my humble submission, my lord.
Money between the appellant and the deceased for the respondent shall
My lord, regarding the law of limitation, my lord, it has been dealt in this judgment by the full bench judgment, my lord, Shala Action Committee, my lord, that Limitation Act is applicable. And the question is here as to whether the provisions of Limitation Act 1963 do not apply to the tribal areas now comprising the state of Meghalaya. And the answer is there in this judgment, my lord, that the Limitation Act 1963 applies to the entire state of Meghalaya, including the tribal areas of autonomous district council or regions. And my lord, there is another judgment also, my lord, by a single bench, my lord.
give us the Limitation Act. Where is the plaint?
My lord, the plaint is at page 52, my lord. Page 52, annexure 2, my lord.
So your suit for recovery of money
Yes, Your
is barred by limitation.
Your Lordship, actually, in this case, in page 27, it's clearly rejected by the District Council that the limitation is not cannot be exercised here, as per here. In the
No, that is because according to them,
yes,
Limitation Act will not apply between the tribals.
yes, absolutely.
No, but there is a three-judge bench decision has said something else. Limitation Act applies to the tribal areas as well. So if it appears to the tribal areas,
No, Your Lordship, as per this Meghalaya Act and rule, is clearly mentioned here in the 34 applications of the Indian Limitation Act is not applicable.
no, but now the three-judge bench has decided that it will apply to the tribal areas as well. So if the Limitation Act applies to the tribal areas as well,
Yes, Your Lordship.
then if she is able to establish that the suit is barred by limitation, unless you show that the suit was filed within the period of limitation. See, on a bare reading of the plaint, you say cause of action arose on the December 2019, when the defendant had threatened the plaintiff of filing harassment cases against the plaintiff and refused to acknowledge that she had taken financial help from the plaintiff in purchasing the aforesaid land property at Lapang. And also you cannot claim ownership of the said property by reason of the Benami Transaction Act. If you say that you have given loan for the purchasing the property in her name, so you are saying that that loan is not that you cannot dispose of the property unless, see, either you have to take out a case of mortgage or is a case of loan against, maybe they call it that conditional sale, but you are not the owner, so conditional sale would not come. So if you have given them the amount for the purpose of purchasing a property, you have no right over the property. They are supposed to pay you back the amount, which they have not paid back.
Yes, sir.
So your case is based on realization of amount. The last payment according to this schedule that you have given is of June 2016. So by June 2019, you have to do 2009 to say you can take from this 3 years, say June 2019. Sorry, 20. No, say 19, sorry. So you have filed the suit in 2020. So is it not expressly barred by limitation? Unless you say that the Limitation Act doesn't apply. But the learned trial judge has not considered this judgment, but he says the Limitation Act applies even to the tribal areas. So here also the district council was constituted after the separation. The full court judgment applies because the learned trial court has not considered this full court judgment in deciding on the point of limitation.
Your Lordship, this as per the order which the district councils they give impugned order, they totally rejected in this one.
Sorry?
But
Sorry, can't.
as for the impugned order, which is direct order details given by the district council,
Yes.
yes, it's clearly they said the limitation act is not applicable.
No, that is now being no more the good law in view of the judgment of the three-judge bench. Have you read the three-judge bench judgment? The first reference is that only. As to whether the provisions of the Limitation Act do not apply to the tribal areas now comprising the state of Meghalaya. It says it does apply. So by reason of that, this Chapter 4, the Civil Justice Rule, because otherwise you see the situation. In one state, you'll have two sets of limitation, one for the tribals and one for the non-tribals.
Yes, sure.
And the Limitation Act has now been made applicable by reason of this three-judgment decision. So Limitation Act applies.
Your Lordship, but here the two parties are the tribals. Two parties are tribal.
It does not make any distinction between tribals and non-tribals. If the Limitation Act applies, it applies in all respect.
So, Your Lordship, as per my understanding, if there's a two tribal, this Meghalaya rule will be implemented.
Limitation Act is there. The Limitation Act will be applicable to the state of Meghalaya. That is the ratio of the judgment. It does not make any distinction between tribal, non-tribal or tribal inter se.
Your Lordship, that the course of the action is March 29, and
That pleading, see, you have to read the plaint as a whole.
yes,
You have given the transaction, all check transaction ending in 2016.
yes, Your Lordship.
Now, when you demanded the money,
2020.
what is your that letter? Show us the letter. You have not stated that in the plaint that it was mutually agreed by and between the parties that the amount would be payable on demand and to be utilized for the business purpose. In view of the fact that he is not repaying the loan, we call back he is not repaying the share, we call back the amount because of that breach occurred in 2019. Then we'd have followed that what you are saying is correct. At least you make an arguable case of limitation. Your pleadings, on the basis of these pleadings, if you said that, you see that I give you a money, maybe a friendly loan, and say that you pay as and when you can. So repayment is not mutually agreed upon. Rather, repayment is on my demand. So I may make a demand after 5 years. At least there ought to have been such kind of pleading.
That there is lordship actually.
Yes,
In page 56.
page
that-
56.
that's- Yes, lordship. This page 56 that my father,
Page 56.
yes, lordship. This is the transaction bill which I gave them.
56.
5-6.
No, 56. This is the payment schedule.
My lord, in the entire plain, my lord, there is no pleading of return of money also. So,
You
my
have
lord,
taken the money, madam, and you have not returned it.
my lord,
That's not a very bona fide defense. These checks are all being given to you. Why should not you not repay it? You forget about the niceties of the plaint. You
lord.
repay the amount.
my lord, may I have instructions, my lord, in this matter, my lord? My lord,
See, these checks were issued in your.
I have come specifically on whatever is there in the plain, my lord.
You have specifically these checks were issued in your name. And
But
you
my
are-
lord, just because the check was issued in my name doesn't mean that I have availed the loan, my lord. My lord, the consequences of availing the loan does not arise just because they have given me the check, my lord. My lord, that is also has to be seen aspect, my lord. And my lord, if I have ever availed a loan, my lord, where is any kind of written agreement or anything from my end annexed in the entire plain, my lord? My lord, at least, my lord, kindly consider, my
That
lord.
is not the point. Point is this: this money was, according to them, given for investment for the purchase of the properties, for the business purpose. Correct?
My lord,
Correct.
my lord, this plaint,
If they can establish at the trial that it was mutually agreed upon between the parties, that on demand this amount shall be paid.
my lord,
And they were unable to pay the
There was-
advance, and there was an understanding that they will, after the commencement of the business, the profit sharing would be there. So
My
this
lord-
all happened in 2019. If this is contended, then where is your order, Sir Vivavan?
my lord, my humble submission.
Better
to
you
the-
take instruction from client, pay the principal amount. pay the principal amount. Money is taken.
My lord, in that aspect, my lord, my only humble submission is that, my lord, the entire amount, my lord, as per the instruction that I have received previously, my lord, there was actually, my lord, that the circumstances arises so she have never borrowed any money, my lord, from the plaintiff, my lord, the father of the respondent. She had never borrowed any money, my lord. And then after that, he had given some money in her account, credited, my lord, but that was nothing to do with the land or anything as it, my lord.
Forget about there's no land. You repay the amount, whatever you have received.
But my lord, if the money, my lord, if the money which is gone into the account, my lord, if it's
The
not
money
for
has
the
gone
loan,
into your account.
my lord,
The money has gone into your account.
correct, my lord, it
So,
has gone into my account, my
then-
lord. Okay, my lord, that aspect, it has gone into my
Repay
account.
the
No
amount.
dispute, my lord, to
Repay the
that.
amount.
But if that money, it's not for loan, then, my lord,
We are not saying about loan.
if it's not nothing for loan, if it's
It's a-
for
it's
the
a-
money
it's a-
which
it's
is
a-
of
it's
the
a-
petitioner herself, my lord, then,
It's a gift.
my lord, you can't see that, my lord.
Don't make out an absurd story.
Your
Ask the take instruction and repay the amount. We'll give you time.
yes.
Not dismissing the suit.
My lord, kindly, if I read para number 5 or number 4, 5, 8, and 9 of the
Will
plea,
you
my
take
lord.
instruction, madam, how you repay the amount? Take instruction.
I'll take instructions, my lord.
Yes.
My lord, kindly list this matter at, after the vacation, my lord, because my,
Provided you give us assurance that you will repay the amount.
my
We will
lord,
not charge you any interest on this. Whatever amount you have received, you just pay it back.
my lord, kindly list this matter at, after vacation, my lord. That's my only humble request, my lord. The rest, I will seek instructions.
Hey, this something there should be commercial morality. Something is above the law. If I want to save the plaintiff, I can save the plaintiff. If I don't want to save the plaintiff, I don't want to save the plaintiff. But it cannot be said that there is no travel issue.
My
We
lord,
cannot say that our orders and 11 will dismiss the suit.
my lord,
Even we disagree because of the limitation act will apply. Limitation is always a vexed question of law and fact. Read the judgment in Popat Coach's case.
my
The
lord,
limitation is a mixed question of law and fact. Popat Cottage properties. You have a mobile now, you can find a reference.
yes, my lord.
So you need not to go. It's a mixed question of law and fact.
Facts, yes, my lord.
Unless on a bare reading of the plaint it is manifest that it is barred
But
by
my lord,
limitation.
in the entire plane, my lord, the entire plane is specifically barred, my lord, because there is no,
Take instruction, madam, how you pay the amount. We'll give you installments. And principal, no interest. And no claim on the property. Come,
my lord, I will seek instruction.
lay down. This matter, this is the name of the matter. Just keep this. Send it to me.
Please, Lordship.
Yes.
Lordship, we are challenging the order dated 22/2024.
this is an order, my lord, wherein the
This is absolutely correct order.
lord, my,
Post suit, post decree, survey taken place, subsequent fact, order 41 rule 27 was allowed.
yes,
There is no ground to
yes.
it.
I'll just place the background, my lord. If my lord,
Whatever the background,
yes, just 2 minutes. My lord.
pre decree is not relevant. Post decree, whatever was there, this is not being disputed. The paragraph starting from perusal of the evidence.
Yes. Yes, my lord. Well, I'll just 2 minutes. I'll place the background, my lord. If my lord's not convincing, perhaps this.
No.
My lord, this suit, my lord, originated in the year 1989. My lord, the respondent herein, my lord, has their predecessor has filed a suit before village court, my lord. Here there's a administration of justice. The lowest level is the village court, my lord, so far as the hierarchy in district council court is concerned. So they file a suit in one village court pertaining to one administrative unit known as Ilaka, my lord. Here, what happens here, my lord, I'll just briefly tell the background in area, my lord. A collection of villages forms one Ilaka. Collection of villages forms an Ilaka. And these villages and Ilaka are under the district council. So, my lord, the system of code is that, my lord, there is the village code in one particular Ilaka, and then there's the district council code, my lord. That is the hierarchy, my lord. So, basically, a suit of first instance is filed before the village code. The predecessor of the respondent filed it in the year 1989, my lord. And subsequently, my lord, we initially participated, but subsequently we did not participate because another village code of another Ilaka wrote to them saying that no, this particular suit land falls under Ilaka. So we do not participate.
Another Ilaka.
Yes, my lord. So we did not participate anymore, my lord, and an ex parte decree was passed against us. We challenged that. And that particular
dispute is that this particular property belongs to which region, which part?
No, my lord. The dispute is whether this property belongs to the respondent or the petitioner.
No.
That is the original dispute.
You said that if the village,
yes, my lord,
if the area is determinable with reference to the villages,
yes,
forming an Ilaka,
yes.
So whether this particular property is in this village or this property is in the other village?
No, because the respondent, my lord, is an individual. It's not a village, my lord.
No, he's an individual.
Yes, my lord.
So he's claiming that I have a share or I am the owner of the property.
Yes.
Which according to you is not the correct situation. So the suit was dismissed.
Yes.
He preferred an appeal.
It was
now,
allowed.
after the preference of appeal, there was a survey done.
Yes, no, my lord. Initially, my lord, after the first round of litigation, ex parte decree was passed against us. We filed an appeal, and in the year 1999, my lord, the district council court has directed for de novo trial. So after that, my lord, then this particular suit was taken up by the regular court of the district council, no longer by the village court, my lord. So after that, my lord, this was taken up by the regular court. After that, both parties participated. Evidence was led, my lord. There were around 14 issues that were framed, my lord. One of the issues that were framed was issue number 2. That is whether this particular land falls under Ilaka A or Ilaka B. That was one of the issue. So other issues, my lord, pertains to
basically a demarcation.
No, my lord. Actually, this
identification and demarcation.
Yes.
Identification.
Yes.
So this will be best available from the survey reports.
Yes.
And the land reports of the Ilaka.
Yes. My lord, although that is one of the issue, my lord, but the main issue here is that who's in possession and owner of the land.
Possession is one issue.
Yes.
On order 41 rule 27, it was determined that, as he said, if you read the judgment why order 41 was allowed, you will find, if you read that paragraph, from perusal of the evidence.
Yes, my lord.
Last but one page.
Yes,
read that paragraph from perusal of the evidence.
Yes, my lord. From perusal of the evidence of the plaintiff and her witness, they stated that the suit land falls under Ilaka Menso, since the law of Ilaka Menso and the law of Ilaka Nonjingi had demarcated the boundaries of the two Ilakas, but do not have documentary evidence to prove that the suit property falls within Ilaka so and so. The defendants and the witnesses stated that the suit property so and so falls within so and so, but do not have any document to show that the sued land is the forest land registered within the Elaka Nongjingi. However, they relied on the letter which was written by the Deloy of Nongjingi Elaka to the Deloy of Elaka Manso. The
That
appellant
was
have-
possibly 1990, if I'm not wrong.
Yes, yes, my lord.
That was
in
on 9
19
June 1990.
Yes, yes, my lord.
Correct?
Yes.
So if the plaintiff was unable, who's filed the suit? You filed the suit.
No, no, it's the respondent.
I
filed
filed
the suit.
Yes, I am the
So
defendant. in this
you have not been able to establish your title. You have no documentary proof.
Your
So
Lordship,
they also cannot say that whether this land belongs to that portion or not. Now read.
Yes, my lord. The appellant have submitted that subsequently after the judgment and decree was pronounced by the trial. This is important, my lord, because this subsequent evidence was collected after the judgment was pronounced.
Yes.
A survey was conducted by the officer of JHDC in the presence of headman and secretary of the adjoining village, and the boundary map was prepared along regarding the land, jurisdiction, and boundary of Elaka Manso and adjoining Elaka. That the applicant came to know of the boundary map only after the decision was rendered, which was not available at the trial stage, and as such, the document was not within her knowledge and could not, after the exercise of
So
due
this
diligence.
is a piece of evidence
Yes.
which he wants to show in establishing a title or possession over the land.
No, my
But-
lord. No,
yes.
This, my lord.
This is an important piece of evidence.
My lord, if I may, I think I'm not able to really put across the actual points here, my lord, because the issue is this, my lord. Suppose here in Shillong, my lord, here in this particular area, suppose in Police Bazaar, my lord, someone is the owner of a particular.
See, question is whether this land is region A or region B.
No, that is one. The primary question is that who owns this land? The second question is that whether this land falls under village A or village B. It does not make much difference, my lord.
No, this direction was for the purpose of determination of this land whether it belongs to A or B region.
Yes, that is one. But the primary suit is that, my lord, is that the respondent is claiming that this land belongs to her. And the secondary issues are that whether this land, who owns this land? Secondary is that where is the location of the land, whether it's in village A or village B, whether in Elaka A or Elaka B.
Order 41, Rule 27 was allowed.
Yes, my lord. My lord, my only grievances is this, my lord. Although they say that this evidence was available after the judgment was passed, they filed an appeal, my lord. And in this appeal, my lord, there's no whisper as to the...
What the appellate court has said, he said that this finding, let us come, because all the issues are to be decided
Yes, my lord.
in the suit.
Yes, my
So
lord.
one of the issue is in which part this land is located.
Yes, my lord. Yes.
So that is, he has not overturned it.
No.
So he also, in deciding that issue, he said that this evidence is required. So record an evidence and send back to me. That's all.
My lord, that is correct, my lord. But my
Then
only
what is the challenge?
my only grievances is this, my lord. When the appeal was filed, my lord, the first appeal was filed before the appellate court. There's no whisper in their pleadings as to the grievances, as to the finding as to that issue, my lord, to the issue number 2. There's no grievances.
But issue number 2 was there.
What's there, my lord?
See, issue number 2 was not, no one has abandoned issue number 2.
Yes.
But for the purpose of deciding the issue number 2, the appellate court felt that this document has now surfaced.
Yes, my lord.
So this will be recording of evidence by the trial court and with the findings sent to the appellate court for a final decision on all the issues.
My only grievances is this, my lord. While filing that appeal, my lord, while filing the appeal, in the pleadings of the appeal, my lord, in the grounds of appeal in particular, there's no whisper as to the grievances, as to their finding with regard to issue number 2. The only grievances that they have is regarding possession and the ownership, my lord. They have no grievances as to the finding of the trial court that this particular land falls under Elaka so and so, my lord. So now,
So for the purity of the record, it should be a proper finding
Yes,
on the issues.
yes,
It's a purity of the record. So this is what has been asked for by the court. I don't think we should interfere with it.
and another aspect, my lord, is this. This application was filed in the 11th hour, my lord.
Doesn't
After we...
They know.
My lord, then my only limited prayer is this, my lord. My lord may kindly appreciate that this is a 1989 suit. My lord can fix a time frame, my lord. Just a time frame, my lord.
In a suit for possession.